Thanks, Senator Grassley. Senator Klobuchar.
Thank you very much, Mr. Chairman. I guess I'll start with you, Mr. Fogel. The Judicial Conference, I think, did the right thing by strengthening the disclosure requirements that apply to judicial officers, including the Supreme Court recently. But the Supreme Court justices are still not bound to the code of conduct, as we've been discussing, for United States judges. Unlike all other federal judges, the code requires that a judge uphold the integrity and independence of the judiciary and avoid impropriety and the appearance of impropriety. How has a formal enforceable code of conduct helped to ensure that the rules are consistently applied for every other judge in the federal system?
Well, who was bound to that for 37 years, both as a state court judge and a federal judge, it really is your North Star. It's what you look at in terms of the values you want to uphold as a judge. And it's something that guides your conduct, and it also is something that the public can look to and say, this is what we expect of our judges.
And do you agree with Judge Ludwig, who was just quoted by Senator Durbin, who wrote the committee to say if the Supreme Court does not subject itself to the highest possible professional and ethical standards, it can depreciate its power?
Senator, I agree with that. I think that the Supreme Court, my hope is, the reason I came here today really is I hope that the court will adopt a formal code of conduct. I think it needs to be modified in some respects because the Supreme Court is different in a number of ways, but I think the absence of a formal code is an issue that I hope that they will address.
I appreciate that and your thoughtfulness. Ms. Frost, thank you. You mentioned the Judiciary Act of 1789. You mentioned the Ethics Reform Act of 1989. You mentioned the Ethics in Government Act of 1978 as reasons that, in fact, Congress has passed laws in the past based on the Constitution about the operations of the court. Is that right?
Yes, that's correct.
Okay, so I go over here to you, Mr. Dupree. I really wasn't planning on asking you questions until you dissed the Department of Agriculture. Because you said their court is not just like the Department of Agriculture. And I was looking up, it was set up by Abraham Lincoln in 1862, being a big ag state that we are, 100,000 employees, serves the people of this country. Yet that department, which basically has jurisdiction over what our farmers do for ranching and farming and counter-cyclical payments. I mean, they've got ethical laws in place. So I actually see the opposite when I think about the power of this court. And I think about what Ms. Frost said. I think there is every reason that this court should have ethical rules like the fine Department of Agriculture, and that we don't look at that as a bad thing. We look at it as a good thing.
And certainly, to be clear on the record, Senator, no disrespect to the Department of Agriculture, which is a hallowed department and agency.
You decided that was the department you were going to mention. And I think a lot of people in the middle of the country noticed it, but go ahead.
Understood. Again, no disrespect. My point with regard to the Department of Agriculture was simply that the provision of the bill, and several bills have similar types of provisions where they basically order the Supreme Court to engage in essentially a rulemaking function. In other words, to promulgate for public notice and comment a code of conduct. Again, analogous to what this Congress would say with regard to either the Department of Agriculture, Department of Defense, Department of Homeland Security, you name it. And my point was simply that as a matter of our constitutional structure, the Supreme Court is differently situated in a profound and fundamental way from Article II executive branch agencies, which can be vested with rulemaking power under the Constitution.
Thank you.
Article III can't.
Ms. Frost, you want to reply? Because this gets to the core of this question of us actually being able to pass a law and do anything.
Yes, I mean, this is the point about Article III of the Constitution. It's very short. It requires that there be a U.S. Supreme Court, as a few other provisions, but it leaves to Congress that essential role of administering the court. And Congress has always done so. So to question that authority today is to question 230 years of consistent practice where Congress has legislated regarding the court. To be clear, not to control its decisions. That is clearly off limits. But every other aspect of the court is controlled by Congress, from its size to when it meets.
Agree. Mr. Payne, why is it important that the Supreme Court also have an ethics office separate from the individual justices to provide them with advice on how to comply with the ethical obligations and to ensure that this office has the authority to conduct independent fact-finding?
The only way that any current ethics rules or future ethics rules will work is if there's a way to enforce these rules and a way for the Supreme Court justices to understand how they apply. So therefore, you need an internal body that can provide the ethics expert advice and also gather facts in the circumstances where there are potential violations that need to be resolved.
Ms. Frost, what do you think on that?
Yes, I would agree with Mr. Payne's analysis there, and I think that one of the problems we've been having today is that so many of these issues get dug up by investigative journalists and splashed across the news in ways that does damage to the court. If they had a more systematic method of adopting or approaching these problems, we could avoid this.
And Mr. Fogel, how would you handle that? Because you've been, trying to thread the needle here.
No, I am trying to thread the needle. I think the court's independence is very important. I agree with other witnesses who have said that. I think there are ways they could do better at getting independent and impartial advice about ethical questions. They don't really have, it's kind of a black box, as I said in my written testimony. They have a lot of sources and rules that they follow, but no one really knows what they are. And I think if they had a internal resource, I suggested, and I'm not alone in suggesting that they get a group of very experienced retired judges whose integrity is unquestioned. And I stress retired judges because then they're not subject to the problem that a circuit judge would have or a district judge would have. To just say, look, I have a question here, I'd like your advice. I mean, what do you think? Somebody who's independent, who doesn't have any skin in the game and can just say, yeah, I think this is okay, or I don't think that's okay. I think that's a modest step that the court could take.
Okay, well, thank you. And Mr. Mukasey, I'm sure we can talk about this in the future as my colleagues await, but you and I have worked together well, including when you were Attorney General, so
We have.
thank you.
Thank you very much.